years after the world's worst industrial disaster in the city of Bhopal in central India killed over 20,000 people and caused serious disability to hundreds of thousands of others, a Bhopal court has finally found 7 senior officials of Union Carbide Corporation of India, including the Venerable Keshav Mahindra, chairman of the Mahindra and Mahindra conglomerate and one of the doyens of Indian industry, guilty of criminal negligence. They face a sentence of 2 years imprisonment and a paltry fine of 100,000 rupees.
It's a complete denial, in fact it's denial of justice to the victims, because there was enough evidence before the court to punish the accused under section 304 part 2, which is culpable homicide, because the evidence clearly points to the fact that the accused had prior knowledge that storing and mishandling of such hazardous chemicals like MIC would result in a huge disaster. So it's very clear that the accused have practically escaped prosecution, because all of them have been granted bail immediately.
A charge of culpable homicide originally filed against them was inexplicably dropped by the Supreme Court, thus placing the world's worst industrial disaster on a par with some road accident. And this despite clear documented evidence, including by an Indian government inquiry committee, showing beyond doubt that the parent Union Carbide Corporation, UCC, and its Indian subsidiary UCIL knew well in advance that safety features available in the UCC plant in Virginia, USA had not been installed in Bhopal, that even the safety equipment that was available in Bhopal were under-designed and not functioning properly, and that various other safety features and protocols had been dropped in order to save money and increase profits. All this was clearly willful misconduct in full knowledge of possible consequences and thus tantamount to culpable homicide. Yet the verdict suggests it was simply negligence on the part of the operating officials of UCIL. This is also the view pushed by UCC then and by Dow Chemicals now, who are the present owners of the then Union Carbide Corporation. Sections of the national media initially hailed the verdict as one that would finally bring closure to the survivors and families of the victims, but backtracked by evening in the face of furious reactions from activists as well as from technical and legal experts. The US Assistant Secretary of State Robert Blake also issued a statement saying the verdict should bring closure.
Let me just say that we hope that this verdict today helps to bring some closure to the victims and their families.
But nothing can be farther from the truth. The verdict, which is certain to grow into a tortuous course of appeals, is in fact just one more milestone in a protracted and sordid series of events going back to that fateful night in December 1984. Justice has not only been delayed and therefore denied, but also destroyed. Accused number 1 in the trial, Warren Anderson of the USA, chairman of UCC at the time of the Bhopal disaster, does not figure anywhere in the verdict. The parent UCC and its Asian subsidiary UCC of Hong Kong also do not figure. Anderson had been declared an absconder, but the government of India in all these years, whether led by the Congress or by the BJP, has never seriously attempted to secure his extradition from the US. Nor has the US government ever made any offer to facilitate bringing Anderson to justice. This willful collusion between successive governments in India and the United States has been cynically pursued in the interests of a budding US-India strategic partnership. This is indeed a high price for India to pay. The verdict and the long chain of events leading up to it are the result of the cumulative, some would say deliberate, failures of the government's investigative and prosecutorial agencies as well as of the Indian judicial system. These events bring out that multinational corporations, in particular US-based corporations, are beyond the pale of the Indian law, and they will be kept that way in order to showcase India as a safe destination for foreign investment. MNCs can operate freely in India with no accountability and no fear of prosecution or punitive action. This is what the US is pushing hard for in the proposed nuclear liability bill now being considered by India, in which all responsibility lies with the Indian operator and none with the US technology provider. As in Bhopal, so with nuclear power. Dow Chemical says it does not recognize the jurisdiction of Indian courts. It seems that for US corporations, it is only Indian money that matters, not Indian lives or Indian laws.